with more severe criminal penalties. That's why I'm before you today with Senate Bill 719. Under the Texas Penal Code 19.03, the identity of a victim as a protected victim gives prosecutors the discretion, it does not require, it gives them the discretion to elevate murder charges to capital murder. While increasing the ages of children were added to this protected list in 1993 and again in 2000, a 13-year-old remains unprotected. Senate Bill 719 would seek to remedy this by raising the age of protected child victims from under 10 to under 15, ensuring that the murder of children too young to even obtain a driver's license would be treated as the heinous crime that it is. If passed, Senate Bill 719 would make it possible for those who commit these crimes to receive a life sentence without the possibility of parole. Members, this bill does not expand the death penalty. We crafted it so that it did not, but it does allow for life without parole. With that, I would be happy to move passage.
Following amendment, the clerk will read the amendment.
Amendment by Kane.
Chair recognizes Representative Kane to explain the amendment.
Thank you, Mr. Speaker. Members, this is a great bill, especially the part ensuring that we're not making young people, those aged 10 through 15, subject to capital murder, but instead life without parole. And so I would say this amendment is about the same concept of young people, that when you murder or someone murdered that's under the age of 10 to 15, we also then ensure that if you murder somebody that's even younger, maybe younger than 1 year of age,
Speaker,
that it should be a crime.
Representative Turner of Tarrant, for what purpose?
The gentleman yield for a question.
Does the gentleman yield for a question?
I do.
The gentleman yields.
Thank you, Representative Kane. When I was coming up, the amendment wasn't on the screen. It is now, but all I see here is that Section 19.06 of the Penal Code is repealed.
Yes, sir.
What is that doing to the bill or to the statute?
Yeah, we're getting rid of defenses to murder.
You're getting rid of defenses for murder? Did I hear that right?
Yes, sir.
Okay. So I'm looking at the code, applicability to certain conduct. This chapter does not apply to the death of an unborn child if the conduct is charged is conduct committed by the mother of the unborn child, a lawful medical procedure. So you are removing, this amendment would remove part of the statute that says it doesn't apply to the death of an unborn child if the conduct charged is a lawful medical procedure performed by a physician or other licensed healthcare provider with the requisite consent. Do I have that right?
Yes, sir. And look, the amendment's not accepted the author, but with that, yeah.
So I'm sorry, with what?
The amendment's not accepted with the author.
Okay, so are you withdrawing the amendment?
No, sir. With that, I do move adoption, though.
Mr. Speaker,
Representative Weiner, for what purpose?
I rise to call a point of order on this amendment under Rule 11, Section 2, that the amendment is not germane to the bill.
Bring your point of order down front. Members, the point of order is withdrawn. The amendment is withdrawn. Does anyone else wish to speak on for or against Senate Bill 719? If not, the question occurs on passage to third reading of Senate Bill 719. Representative Stickland has requested a record vote. A record vote is granted. The clerk will ring the bell. Have all voted? So Representative White voting aye. Representative Ashby voting aye. Have all voted? Have all voted? Being 119 ayes and 19 nays, Senate Bill 719 is passed to third reading.
Mr. Speaker.
Mr. Doorkeeper,
Mr. Speaker, I have a Senate messenger at the door of the House.
please admit the messenger.
Mr. Speaker, I am directed by the Senate to inform the House that
Thank you. Chair lays that on second reading, Senate Bill 295. The clerk will read the bill.
SB 295 by Lucio, relating to the unlawful restraint of a dog, creating a criminal offense.
Chair recognizes Representative Davis of Harris to explain the bill.
Thank you, Mr. Speaker and members. 12 years ago in 2007, the legislature passed a restraining law to all right. However, the law included an enforcement provision requiring a 24-hour written notice prior to issuing a citation.
Mr. Speaker,
Unfortunate.
I raise a
Mr.
point of order
Strickland,
against
for what
further
purpose?
consideration of Senate Bill 295 under House Rule 4, Section 32C.
Please bring it down front. Representative Stickland raises a point of order against further consideration of Senate Bill 295 under Rule 4, Section 32C2, on the grounds that the bill analysis is substantially misleading. Mr. Stickland argues that the bill contains several exceptions to prohibited conduct that constitutes the unlawful restraint of a dog, yet the bill analysis merely indicates that the bill provides certain expectations of these prohibitions. The expectations referenced by Mr. Stickland constitute at least as much text of the bill as the text that sets out the prohibited conduct. While the bill analysis describes the prohibited conduct in detail, it only makes a passing reference to the exceptions. Under prior precedent, the chair finds that the bill analysis provides insufficient detail of the bill's contents. Therefore, the bill analysis is substantially misleading. Accordingly, the point of order is well taken and sustained. Chair lays out on second reading Senate Bill 1804. The clerk will please read the bill.
HB 1804 by concourse relating to the entry into the Texas Crime Information Center of certain information regarding conditions of bond imposed in criminal cases involving family violence.
Chair recognizes Mr. Navarez for a motion.
Thank you, Mr. Speaker. Members, I move to postpone further consideration of Senate Bill 1804 until Tuesday at 8 a.m.
Members, you've heard the motion. Is there any objection? Chair is none, so ordered. Chair lays out on second reading. Chair lays out as a matter of postponed business Senate Bill 2432. The clerk will please read the bill.
HB 2432 by Taylor relating to the mandatory removal of a public school student from the classroom following certain conduct.
Chair recognizes Mr. Sanford to explain the bill.
Thank you, Mr. Speaker. Members, no teacher should ever feel threatened in their classroom, and no teacher should feel powerless if they are threatened. Our teachers are there to educate our children and should feel safe in their classrooms. This bill would add the offense of harassment by a student against a school employee to the list of removals to a disciplinary alternative education placement, and we have some amendments.
Following amendment, the clerk will please read the amendment. Following amendment, the clerk will read the amendment.
Amendment by Gonzalez of El Paso.
Chair recognizes Rosen Gonzalez to explain the amendment.
Thank you, Mr. Speaker. Members, first I want to thank Representative Scott Sanford, who's been so wonderful. He really laid out the bill and said we want our classrooms to be safe. In creating public policy, we also want to protect our most vulnerable students, and so we've been working with a bunch of stakeholders to put in a proactive measure to make sure our most vulnerable students, by adding the threat assessment teams, which Dr. Bonin is going to talk about tomorrow during our school safety plan, and I move passage.
Mr. Speaker.
Mr. Johnson, for what purpose?
I'd like to ask.
Does the lady yield for questions?
Of course.
The lady yields.
Representative Gonzalez, on your amendment, you're asking for an assessment to be offered prior to a student being placed or being sent to DAEP?
Yes, sir, exactly. So what we want to do is make sure that a kid who does demonstrate behavior that is concerning, before they're put into DAP automatically, that we utilize a tool that we're creating through school safety to make sure that the kids aren't wrongly placed in a DAP program.
So currently, the law in terms of harassment includes annoying. And does your bill simply say that we're going to throw every ninth grader in Texas is annoying? I mean, let's be real. I mean,
Hey,
if
some
you have
members
children
on the
this
floor.
floor, you got an annoying child. But the bill specifically says that if a teacher feels like they're being annoyed, this constitutes harassment. Does your bill or amendment protect our students from simply annoying a teacher before they're deemed to be sent to DAEP?
Representative Jarvis Johnson, I had the same concerns. I don't want a kid who is either considered annoyed, or a kid who has dyslexia or autism to be wrongly placed in a DAEP. We know once we put them in that space, they will forever have a different educational experience. So we put this amendment in place to proactively make sure we don't wrongly hurt any child. And that's why we're utilizing the tools that exist that will really help the student and the school holistically.
So again, we're making sure this happens before.
Yes, sir.
So this assessment will happen before a student is sent
Exactly.
to DAP.
Yes, sir.
Thank you.
Thank you, Representative. I move passage, but I think it's acceptable to the author.
Mr. Speaker, I want to.
Mr. Johnson.
I want to make I want remove to make our remarks.
Reduce to writing and place in the journal.
Thank you, Mr. Speaker.
Members, you've heard the motion. Is there any objection?
This is my first time being on the back mic. Thank you, Mr. Speaker.
So ordered. Mr. Gonzalez offers up an amendment. The amendment's acceptable to the author. Is there any objection? Chair is none. The amendment's adopted. Following amendment, Mr. Johnson. Okay. It's probably good. Following amendment, the clerk will please read the amendment.
Amendment by Tallarico.
Chair recognizes Mr. Tallarico to explain his amendment.
Thank you, Mr. Speaker, members. And I also, like Representative Gonzalez, want to thank Representative Sanford, who took our concerns very seriously and helped us make changes to the bill that would alleviate our concerns. My amendment is fairly simple, but it has a big impact on how many kids will be affected by this legislation. So currently, harassment is defined in the bill by Section 42.07 in the Penal Code, and it includes 4 parts of that definition, 3 of which I think are fairly common sense definitions of harassment, including threats of bodily harm, false reports of death or bodily harm from another person, or repeated electronic communication that's meant to harass someone. But the one part of the definition was A1, which is obscenity. So a student who is communicating with a teacher with the intent to annoy by using obscene words. And if anybody who has taught middle school like I have, that happens almost every day out of middle school. In fact, it happens on our floor almost every day. And so we wanted to take out A1, so that's all our amendment does, is takes out A1 from the definition, includes the other 3, and I believe it is acceptable to the author. I'll also just say that I voted against the bill in the committee, but I will be voting for the bill now that with these changes, and I thank Representative Sanford for that. And I move adoption.
Mr. Tallarico sends up an amendment. The amendment's acceptable to the author. Is there any objection? Chair is none. The amendment is adopted. Following amendment, the clerk will read the amendment.
Amendment by Dutton.
Chair recognizes Mr. Dutton to explain the the amendment.
Thank you, Mr. Speaker and members. This amendment, Chapter 37 of the Public School Code, was really designed by some folks when I was making an objection to students being expelled to the street. And so we came up with Chapter 37 as a way to fix it so that you would never expel the child to the street. one of the things that always concerned me about it, though, was that we asked a child psychologist when he came to public ed one day, does a child's behavior cause their lack of educational achievement, or does their lack of educational achievement cause their behavior? And I'm sure you were like I was. I was surprised, because what he said was their lack of educational achievement generally causes their behavior. And what concerned me about that is the quality of education in the DAEP is a whole lot less than what you get in the traditional school setting. And so what we're essentially doing was guaranteeing that the behavior was going to continue. One of the things that concerned me too was that when a student gets placed in a DAEP, it's almost like they don't have any defenses, they don't have anything. You just show up one day and you can be accused of annoying a teacher, and you go to the DAEP. What this amendment does is says that within 3 days, at least they'll have a hearing at the school where the principal will be there and the parent of the child will be present, so that at least you can determine to what extent did the child engage in that behavior and whether placement in the DAEP is absolutely necessary. If you read Chapter 37, what it does is it provides certain defenses for a child's behavior, but in this bill, none of that is present. And so I would ask you to consider this amendment as a way to make this bill a little bit better, because it doesn't stop you from being placed in the DAEP. It just simply says that we're going to have a hearing on this to take a look at it to make sure that it's at least fair to the parents and the students who are charged with some offense that requires placement in the DAEP. And I'll be happy to answer any questions, Mr. Speaker.
I think we did fix that with Mary's amendment.
What did you say?
She put a threat assessment in.
So your bill does not prohibit them from going, it just says you got to do it 3 days before.
You got to have a hearing.
But 3 days before.
At least 3 days.
But it doesn't stop them from going.
The amendment is withdrawn. Is there anyone else wishing to speak on, for, or against the bill? Seeing no one. Chair now is Mr. Sanford to close.
Thank you, Mr. Speaker. Members, thank you for all of those who've worked with us on this bill. It'll be an important bill to help make our conferences, our
Mr. Johnson, for what purpose?
Ask the gentleman a question.
The gentleman yield for questions.
Yes, sir, I do.
The gentleman yields.
Mr. Sanford, thank you. While I understand the bill that you are bringing forth, I believe that it gives protections to our teachers, because our teachers need the opportunity of teaching without the harassment or the interference of outside forces. Does your bill offer the opportunity for a teacher, simply because they may have had a bad day, because they have been annoyed by a child, to send a child to DAP?
With the Gonzalez Amendment, it does not.
The what?
With the Gonzalez Amendment, it does not.
So prior to any teacher being able to send a child to DAP based on the amendment, we first now have to have this assessment. And the assessment will then determine, will there be a matrix and a score based on that? Or how will we make the assessment accountable to ensure that a child, for the very first offense, does not or is not sent to DAEP because they simply annoyed a parent or a teacher?
As I stand here today, I'm not exactly sure how the threat assessment teams will work. Representative Gonzalez laid out before you what they will be made up of, and they will go through their assessment based upon the needs of the child at the time, upon their history, upon any identified needs that they have, and then observe the behaviors that have been identified by the teacher that have led to this issue or to this problem, and then recommend a course of action from there.
But your bill is simply with the intent of punishing persistent behavior or bad behavior that may be interrupting instructional class time.
The purpose of this bill is to make sure that our teachers feel safe in their classrooms, and if they identify an assault from a student toward themselves, that they have a course of action to remove that student or to have remedial action.
I completely agree with the assault aspect of it. I completely agree with the threat aspect of it. But in your bill, it simply says, an aspect of your bill simply says annoying. If a teacher feels annoyed by a student, they could be sent to DAEP. I want to make sure that that's not your intent of this bill, is to send a child to DAEP simply because a child annoyed a teacher. I want to make sure that it is the intent that this is persistent behavior by which a teacher has exhausted all necessary disciplinary possibilities before we have sent a child to DAEP. Maybe there was suspension, maybe there was in-school suspension, maybe there was detention, but we simply are not sending a child to DAEP because a teacher was annoyed by a child's behavior.
Well, thank you, sir. Was there a question you wanted me to answer?
That was my question. Is your intent, your intent is not to send a child to DAEP simply because a teacher feels annoyed one time? I'm asking.
Well, no, the bill doesn't allow for that at all, because a person commits an offense if with intent to harass, annoy, alarm, abuse, etc. Then there lists 7 different things in the penal code, and and of course we've limited that with this bill and with the Tallarico Amendment.
I want to make sure that we are on the same page with the intent. I want to make sure that your intent, again, is not to send any child to DAEP, which if a child is sent to DAEP, it is a part of their record. Well, in order for them to move on to college, that's in their record. I want to make sure that a child cannot be sent to DAEP simply because they annoyed a teacher one time. I want to make sure that the intent of this bill is not to send a child to DAP simply because of that. I'm just simply asking you to tell me the intent of that is not this.
Well, I think you've been involved with our conversations throughout this afternoon and this evening in the crafting of the amendments that we've entertained, and I think that the intent is wrapped up in those amendments. and the bill itself. And it's pretty clear that the steps you have to go through to get to a DAP situation and protect the teachers at the same time.
I want to protect teachers, and I know you're trying to protect teachers, but I don't want to punish a child. Because
well, at some point, a kid may have to go to DAEP, Representative, and so my intent is not to preclude anybody from ever going to DAEP.
But I don't want to send a child to DAEP simply because a child is inquisitive, or because a child asks why, or because a child is demonstrating leadership. Everyone in here is A-type personalities, and if they question their teachers, political views, would that be considered harassment, is my question. I want to make sure of that. That's all I want to make sure of. Other than that, I want to make sure that we're not simply punishing an inquisitive child or a child that simply asks why.
The bill doesn't do that, Mr. Johnson, but it does. If a student threatens to harm the teacher, to kill the teacher, to harm or kill their family, or makes false claims of such things, that is what this bill is intended to address and does address.
Thank you.
Thank you, sir.
I want to thank my colleague, Mary Ann Perez, for handing me this note. It says, Mr. Speaker, I move that the conversation between Representative Sanford and I be reduced to writing and placed in the journal.
Members, you've heard the motion. Is there any objection? Chair is none, so ordered. Question occurs on passage of Senate Bill 2432 to third reading. All those in favor say aye. Those opposed say nay. The ayes have it. The bill is passed to third reading. Chair lays out on second reading Senate Bill 2293. The clerk will please read the bill.
SB 2293 by Fallon, relating to the applicability of certain laws to open enrollment charter schools.
Chair recognizes Mr. Dutton to explain the bill.
Thank you, Mr. Speaker. Members, I don't usually agonize over a bill, but I have over this one because some of my friends apparently